Size of right. Article 183 plus 1. The review. That's it. 183. I'm sorry. 183. The review is on the court. Especially my contention is that this provision is a rule under which a person aggrieved by a decision of the court comes by to seek a review or variation of the decision. The instant application is not an application for review. It doesn't invoke the court's review powers and is therefore unknown to the laws governing the jurisdiction of the court. Especially Article 134 also vests the Supreme Court with the same powers of review of a decision of a single justice. Indeed, the decision in question was not by a single justice. But the point I seek to make is that whenever a decision of the court is being sought to be reviewed, varied or discharged, the procedure for doing so is as set out in the Constitution. And this is not an invocation of any of those procedures. The second point we make is that the application mixes up grounds for a substantive defense to the action with matters that, in the view of the first defendant, constitutes a basis for a setting aside of the service. And this respectfully is wrong. The court will notice that on the face of the motion paper, the grounds for the application are stated as, and I'll quote, I'll just be quick about it. The rate by which the plaintiff has reportedly invoked the court's original jurisdiction is incompetent. The court has no jurisdiction to detain the suit before the court. The court has no jurisdiction to stay execution of a will of the Speaker of the Parliament of Ghana. Respectfully, paragraphs 12 to 18 of the affidavit in support also raise matters which constitute a substantive defense to the action. And I respectfully will quote paragraph 12. So the words used in Article 97 plus 1, paragraphs J and H of the Constitution are clear, unambiguous, and have no disputed meaning, and no basis exists in the processes filed for assuming that there's dispute. Then paragraph 13 is that the words used in the provisions of Article 97 plus 1, paragraphs J and H simply mean what they say. That is to say, when a member of Parliament leaves a party on the ticket of which they are elected to Parliament to join a political party or to become an independent member of Parliament, or when a member of Parliament elected as an independent member of Parliament joins a political party, they shall vacate their seat. Especially, I will turn over to paragraph 29 to 32 of the affidavit in support.
Do you have 10 minutes?
Yes, please. My lady, I'm still well within the time. I'm sorry. So, it says, paragraph 31. Further, the 19th Constitution of the Republic of Ghana provides for the well-known separation of powers doctrine, whereby the scope of the powers of each arm of government is set out, and no arm of government is expected to overstep its bounds. The same defendant takes the view that the writ does not invoke the decision of the court because, in the view of the defendant, the words of the Constitution are clear. The rules do not permit the filing of an application to set aside the writ on that basis. Indeed, there will have to be in a statement of case filed at the point raised for determination by the court. And the court will notice that indeed that issue is actually one of the issues set out by the second defendant for determination. The second defendant does the Attorney General file issues for determination in this matter, and those are issues raised and which conceives the Supreme Court's original jurisdiction. And I made the point that indeed the court would notice that Article 2 plus 1 of the Constitution constitutes the principal mechanism, with all respect, for enforcing the Constitution. And in examining Article 2 plus 1, I pray the court not to look only at the article, but to even read it with Article 3 plus 1 of the Constitution. Article 3 of the Constitution Article 3, the whole of Article 3 of the Constitution, imposes a duty on all citizens to defend the Constitution at all times. Respectfully, there is no better mechanism for defending the Constitution by seeking an interpretation of the Constitution whenever a provision of the Constitution is in contention or a controversy has arisen in respect of that provision. Clearly, the meaning of Article 97 clause 1 paragraphs J and H, as advanced by my learned friend, Counsel for Defense Vacant, on which he says are clear, have been contradicted by the plaintiff in this case. And indeed, I have also duly filed a civil case in it, and totally his understanding, with all respect, is wrong. There cannot be a more demonstrable case for a controversy as having arisen in respect of a provision of the Constitution than the instant case. But my respectful submission is that indeed it will be a recipe for chaos, lawlessness, and a danger to the security of the state for a person to contend that merely on account of his own understanding of the Constitution, which he says are clear, a writ issued duly invoking the decision of the Supreme Court has to be set aside. And that would be the basis for lawless conduct. And this honorable court owes a duty not to encourage him. I'm fortified in this proposition by the locus classicus on the matter to follow an Attorney General reported in 1980 Ghana report at page 637. And where the Supreme Court stated clearly that whenever a controversy has arisen in respect of a provision of the Constitution, it is a basis for the invocation of the court's original duration. Respectively, the points I make today are not points being sought to be established today. They are matters that have been long established 40 years ago in this honorable court. I quote from page 650 of the provision. And indeed, it was also a controversy regarding a decision by Parliament. Parliament had actually made a decision to subject the Chief Justice of the Republic to vetting. The Chief Justice had also even acceded to that process. The Supreme Court said that, notwithstanding the Chief Justice's decision, insofar as that decision was unconstitutional, it could form the side matter of the original decision of the Supreme Court. But the court stated that there's a controversy regarding the status of the incumbent Chief Justice, the determination of which depends upon an interpretation of the Constitution. Once there's a controversy, a justiciable issue, we believe that under the wing of interpretation as contained in paragraph A of clause 1 of article 118, the court has jurisdiction to detain the issue raised by the plaintiff's right, and the plaintiff is thus properly before the court. And respectively, the court went ahead to make the point that in a constitutional action, the community of interest is with the Constitution. There's even no such thing as a plaintiff and a defendant, and therefore the writ which mentioned some members of Parliament, there must be a demonstration of an interest in them. There's no such thing as that. Indeed, the plaintiff, with all respect, could have omitted reference to any member of Parliament and have just stated a question for determination by the court whether upon a true and proper interpretation of Article 97 clause 1 paragraphs J and H of the Constitution, a seat of a member of Parliament becomes vacant upon the occurrence of A and B. And that is it. And the court will have been seized with their jurisdiction. Maybe the first defendant makes reference to an alleged denial of the right to a hearing, auditory pattern by the filing of a motion ex parte. My respectful quick answer is that indeed the law even envisages such a procedure, and there cannot be a denial of any natural justice, right to natural justice, in the court entertaining an application for application ex parte. But if indeed it was the case that whenever a motion ex parte is brought, there is a denial of the right to a hearing, then indeed the court ought to scrap from its procedures and rules motions ex parte. This submission is totally incongruous, totally offensive to the long or the age-old practice in this honorable court. Respectfully, I would respond to the contention made by my left friend that there was an understanding of the CJ with the Speaker of Parliament and all that. I will not seek to even go into the merits of the understanding. But the point must be made that constitutionally.
No, hold on, please.
Right.
I think that for the benefit of the public
right.
of this nation,
right,
it is important to address the facts behind that matter.
Right.
As they be. Because there had been a circular in 2021 to regulate service on members of parliament. And indeed, the Speaker of Parliament invited me as Chief Justice to discuss the return to that regulation. So I reviewed what my predecessor did, and I issued a circular. If anything, I think your submissions may address the import, the legal import, and nothing more.
Right. Maybe in addressing the legal import of that circular, I would note respectfully that I'm just putting forward a circular that what is paramount before the court in an action of this nature is the proper interpretation of the Constitution. And indeed, as held in before an attorney general, even if, assuming it had written, even if the CJ had written such a letter, for me, with all respect, it's immaterial.
It's a circular.
The circular, written such a circular, it is immaterial for me. It is a construction of the words of the Constitution that matter. Before an attorney general even indicated that the Chief Justice, who had lent himself to the process, which was subsequently pronounced upon as unconstitutional by the court, could not have waived any right whatsoever. Because there's no such thing as exequatur under the Constitution. And indeed, I look at the provisions, the words in Articles 117 and 118. All it says is that civil or criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member of the Clerk of Parliament while he is on his way to attending acts or returning from any proceedings of Parliament. In my respectful view, I do not see Monday in Article 112, 117. I do not see Monday there. I do not see Tuesday to Friday. I do not see all that must be understood clearly. Irrespective of that circular, in my respectful view, I, the attorney general, can, or any citizen of the land, having invoked the decision of the Supreme Court, can serve the process on a member of Parliament, the Speaker of Parliament, or a clerk to Parliament, except when he's on his way to Parliament or returning from Parliament. That is what it says. But again, there is an attempt to suggest, and it was implied in the submissions relating to the Supreme Court overstepping its bounds and what have you, that Parliament of Ghana, I know I have the right to reply, but it's done over 25 minutes. Yeah. We've been checking.
Attorney General, you have 1 minute left.
But I don't have the right to reply, especially that he got up only on points of law. So but he's exceeding.
Yes, the point of law are many because of application.
Please don't waste your 1 minute.
But the point I'm making is that the Supreme Court's judicial review powers, first one to Articles 2 clause 1 and 130 clause 1, extend to any authority, institution of state, or any individual in the country. No arm of government, no institution of state, and definitely no individual is exempt from it. Indeed, the President himself is even subject to Supreme Court's judicial review powers under the Constitution. And the Constitution spells out the consequences for a failure to obey decisions and orders and directives of the Supreme Court. That is in Article 2, Clause 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high command under this Constitution and shall, in the case of the President or Vice President, constitute a ground for removal from office under this Constitution. So clearly, the powers of the court can never be questioned at all. And it is for this reason that the Supreme Court in Kifo and Atenjera and further fortified by D.H. Mensah and Atenjera reported in 1996 Supreme Court of Ghana law report stated clearly that in Ghana there's even no such thing as a political person. The court can call into question any act or omission of any person at all, insofar as it's in violation of the Constitution. So the contention by my friend Counsel for Fair Defendants that it was an administrative decision of the Speaker. And so, with all respect, I'll ask, and so what? Any administrative decision of a person or authority which comes in contravention of the Constitution is amenable to the court's judicial review powers. I strongly submit that the application before you is totally offensive to all rules and procedure of this honorable court. It's unknown to the laws of Ghana and must be dismissed. I pray accordingly.
Just some short points of law, especially that they were made on points of law, and I'll be very short. First point, that the application is unknown to any rule or procedure and offensive and all of that. First, the simple answer. Since the days of Mosi and Bajina, elementary, first rule in the civil procedure classes, if an order is a nullity, you can come by any procedure to set it aside. It remains the law following from that. He likes to cite cases of vintage. He says over 40 years. She calculated when Mosi and Bajina was decided, 1963.
Mr. Sorry, all your juniors are here.
They were here when they say there is a misconception and a misunderstanding. They have remained here. And this is the clearest example of a misconception and misunderstanding. I said from 1963 up to 2000, and we are now in 2020 something. It remains the law, elementary first rule. 2, that I'm challenging the jurisdiction of the courts, and I'm saying with all due respect, some matters don't fall within the jurisdiction.
Some matters do not.
That this matter doesn't fall within the jurisdiction of the court, and that I'm mixing matters that should go through the defense and then an objection.
Now the point made is that if you are urging that the writ is incompetent, that should be separated from submitting a defense to the substantive action. That's one. Second, that if this court gives an order and you wish for it to be vacated, reversed, varied, discharged, the onus is on you to bring an application under the review jurisdiction of the court, and not an application such as you have crafted. That's the point.
And I'm saying that the tried principle of civil procedure is that the rules of review aside, this court delivers judgment according to 3 main yardsticks: statute law, common law, and the well-known practice of the courts. That has been consistent. And the well-known practice of the court and the common law is that you come and set it aside. And I'm saying way back from everything up to date, that remains law. So this is not a point. Secondly, if I am challenging the jurisdiction of the court, there are 2 ways and several ways. Elementary civil procedure, I can take it in limine or put it in my defense, and I'm taking it in limine. Another elementary point. Now, let me just look. The Article 2.1 Tandrosley said, in all of the cases involving Article 99, the jurisdiction of the court to determine a membership of Parliament, they also come under Article 2.1. But the court has always said that yes, if they didn't invoke Article 2.1, they wouldn't have been here. But the court has said, look, we will keep our streams clear. Then you cite to for an Attorney General and about the fact that the matter is within.
Your 1 minute is up.
Well, there are other cases. More recent vintage, they all say clearly that that would not be a reason for the court to entertain jurisdiction. And that's what they said back. My Lord, the Chief Justice must have had reason to issue with and the speaker must have had reason to respect it.
And it has constitutional power.
If it's not constitutional, he knows what to do. He should come and declare it unconstitutional. But otherwise, then the speaker should feel deceived by it. That's the point.
You are done.
I'm done. But if my time was happening.
The case is stood down for the court to rule.
All rise. Benjamin, please tell them to switch it off. Tell them to switch it off. Please now, hurry up. They should switch it off.
Lawyer for the Speaker, Mr.